Hi, welcome to Chapter 12 on the judiciary. So just an overview of what I'll be covering. We will talk about judicial federalism, the state and federal courts, and their different roles, structures, and powers. I'll teach you about the three kinds of cases that the Supreme Court hears. We'll cover some important judicial concepts and procedures like stare decisis, precedents, writ of certiorari, the opinion, and the rule of four. We'll talk throughout this lecture about the role of politics in the selection and confirmation of federal judges, and then also consider the checks on judicial power from the other branches of government, from public opinion, and from judicial traditions and doctrines themselves, sort of built in. So, an overview. As we know, the Constitution has a ton of detailed instructions for Congress, right, in Article 1, some rules for the executive branch in Article 2, and the judiciary, unfortunately, gets the least attention of all. The Constitution vests judicial power in the Supreme Court without actually specifying the number of justices that they're supposed to have, and gives power to Congress to design the rest of our federal court system. So a lot of power in the US government is decentralized. It's sort of divided, right? You have the two chambers of Congress, right, with the committees and subcommittees. You have the executive branch split into different departments, agencies, commissions, etc. And the judicial branch is no different, right? It's divided as well. And this is what we call judicial federalism. So the lower courts conduct trials. The appellate courts hear appeals, right? Because they're almost like, right, appellate means appeal, right? They're appeal courts. And both the state and the federal Supreme Courts give final verdicts, right? Because you have state Supreme Courts and you have the federal Supreme Court. The federal Supreme Court is the ultimate arbiter for all cases, right? But the Supreme Court doesn't review that many lower court cases. They only review about 7,000 per year, and they accept and hear only about 80 or fewer. So that leaves a lot of authority in the lower courts. Lower courts and the state appeal courts handle most of the cases in the United States every year. The first stop in most cases is a state trial court, and of course any appeals go to the state appellate court. If there is a high-profile case or any appeals from the state courts, that can be heard in the federal Supreme Court, right? You basically appeal until you get all the way up to the federal Supreme Court. And many landmark cases originated in state courts, right? For instance, like the 2012 decision to uphold the Obamacare health reform law. That started in the states. Another one is the Supreme Court case, the case that legalized marriage, right? It actually started at a lower level and got appealed all the way up to the Supreme Court. But again, that's pretty hard. Just a few of the millions of cases every year reach a federal judge. So like I said, state courts are the workhorses, and they are responsible for any cases that are under state law, right? Murder cases, medical malpractice, drug possession, bankruptcy, foreclosures, any kind of civil or criminal cases that are under state law. Now, the federal courts hear three kinds of cases. Firstly, crimes that violate federal laws, right, that involve federal treaties, or any cases touching on the Constitution. For example, terrorism, immigration, organized crime, civil rights, patents, flag burning, etc. And this is important. Since 1789, the Supreme Court was granted the power to assess a law or action that Congress did. If they decide, right, if the Supreme Court decides it's in conflict with the Constitution, the Supreme Court judges can overrule it, right? They can rule on it and overturn it. So when there's doubt about what the Constitution holds or implies, the Supreme Court makes the call. And this is actually the judicial check on executive and legislative powers. Right? So the Supreme Court has judicial review, right? This is very important. The power to determine whether something done or a law is constitutional. Secondly, the federal courts deal with disputes that spill across state lines. For example, interstate drug trafficking or conflicts that involve parties from two different states with at least $75,000 in dispute. Right? Because it would be difficult to have two state courts ruling on it, right? If it's between Illinois and Indiana, which state arbitrates, right? So that goes up to the federal courts. Lastly, the federal courts arbitrate over appeals from the state courts, right? If someone is unhappy with the ruling that the state court provided them, they can appeal to the federal court. Now, of course, as we know, this doesn't necessarily mean that everything goes up all the way to the Supreme Court, the federal Supreme Court, but you can appeal, and certain federal courts may potentially hear it. So, most federal cases begin in one of the 94 district courts. Each state has at least one district court, and larger states have more than one. For example, Florida has 5 district courts. These courts determine the facts of the case, they build a record detailing the evidence, and then they try to apply the law to reach a ruling. Above these 94 districts is the circuit courts, aka the U.S. Court of Appeals. So if someone wants to appeal their district court ruling from here, they can appeal to this next level. And these judges rule on the basis of the record established by these lower courts. There's no jury, no cross-examination. And these courts are organized geographically. So let's say there is an appeal to a district court case in Florida. The person actually goes to the 11th Circuit Court of Appeals, which is actually based in Atlanta, right? So if you start here at the lower level, let's say you're not happy with your ruling, you can appeal to the Circuit Court of Appeals, right? And for us in Florida, that would mean going here to the 11th Circuit Court, right? A person can also petition the Supreme Court to review the appellate court's decision, right? The Supreme Court being the highest court in the federal court system. As I mentioned earlier, though, very few court cases go all the way up here. They review a very small percentage of the cases and only cases that deal with federal law. So usually any decisions made at the second level here are final. Interestingly enough, only 15% of Americans can name the Chief Justice, this guy, John G. Roberts Jr., who is beginning his 7th term as the Chief Justice. Sadly, twice as many people know that Randy Jackson was a judge on American Idol back in the day. This is according to a survey by the Annenberg Public Policy Center of the University of Pennsylvania. This is our current Supreme Court justices. Now, Antonin Scalia just recently died, so it's just these people besides Scalia. And you have some Supreme Court justices that kind of lean left and lean right. They lean conservative or liberal. This Roberts Court currently has shown itself to be a bit more conservative than in other decades, more pro-corporations and highly protective of free speech. It was, well, at least since Scalia, I mean, if you included Scalia, it was a 5-4 split. I'll talk more about this in a couple slides. Just kind of wanted to give you an idea of the Supreme Court justices here. So you have the conservatives, you have Roberts, you have the late Scalia, obviously not anymore, Clarence Thomas, and Judge Alito. The liberals are Ruth Bader Ginsburg, Sotomayor, and Kagan. And where's Breyer? Breyer right there. The in-between is Justice Kennedy. He is a Republican appointee, but tends to go a bit left sometimes or libertarian. So, which cases are actually going to reach the Supreme Court if we're going to continue our focus on the Supreme Court here? It's not enough just to appeal from a lower court, right? The judges have to choose the case in order for it to be heard. And they choose to hear a case based on certain factors. Firstly, if a legal question has been ruled differently by different lower courts and it needs a resolution, right? So if you have two federal courts, two lower courts that rule differently on something, right? So if something is ruled one way in California and the other way in Illinois, right? For instance, with gay marriage, right? In some states it was legal based on ideas of the Constitution and constitutionality. In other cases, in other states, it was illegal. That's why the Supreme Court had to make a ruling, because we had conflicting laws, right? Or if a federal and a state ruling are different, right? So if there's something needs a resolution, the Supreme Court is the ultimate arbiter. The Supreme Court will also hear a case if a lower court's decision is in conflict with an existing Supreme Court ruling. This actually happened in 1989. So the court ruled in a case called Penry versus Linnell that a death sentence was sometimes permissible for criminals under 18. A decade later, a Missouri Supreme Court declared that the death penalty was cruel and unusual punishment for minors. They were citing a recent Supreme Court ruling that struck down capital punishment for mentally disabled people. Later, in 2005, there was another case, Roper v. Simmons, and the Supreme Court agreed that minors should not have to undergo the death penalty, right? Based on all of these different court rulings, right? You had initially Penry versus Linnell saying the death sentence could be okay for criminals under 18. 10 years later, the Missouri Supreme Court says, nope, that can't be the case. We decide against the death penalty for minors. And so considering all of these, right, all these sort of conflicting rulings, the Supreme Court overturned their 1989 decision originally. And now it's no longer the case that minors can have to undergo the death penalty. Okay, so courts or cases that need resolution, cases that may have conflicts with existing Supreme Court rulings, right? Remember that was the Missouri one. They also will hear cases that may have lasting significance beyond this case, beyond the parties in dispute. And to understand this, we have to understand what precedent means and what decisions according to precedent kind of undergoes. So let me give you kind of a quick spiel on this. So the Supreme Court is based on the English common law system. Basically, our court system is the English common law system, which means that laws are based on judges' decisions, and any new decisions they make are based on previous decisions in earlier cases, right? So things have precedent. If you make a ruling a certain way, you usually make further rulings in reference to those original rulings. Not always, but most of the time. So this practice of deciding new cases with reference to former decisions, aka according to precedent, has become the way that English and American law is made. So since these laws could provide the basis for new laws to come, right, the Supreme Court usually takes cases that are important, right, because they may have lasting significance beyond this particular case, right? So the idea of ruling according to precedent comes from this doctrine of stare decisis, right? And this literally means stand by the things decided. So that's where we get those two. The last case sort of characteristic that decides whether or not the case has reached the Supreme Court is whether or not the Solicitor General is asking the court to take the case. The Solicitor General represents the federal government before the Supreme Court, and he or she promotes presidential policies within the court, and also in some cases recommends cases that the government requests, right, the Supreme Court to take. So these are generally speaking the cases that the Supreme Court will take. But the rule of 4 always has to apply. This is pretty self-explanatory. At least 4 Supreme Court judges have to agree to hear a case before it comes before the court. And I have a star here because if there's less than 7, I think 7 or less judges, it doesn't have to be 4. This is 4 out of 9 currently. So if the court decides to hear the case, it will issue a writ of certiorari, saying, yes, we'll hear it. So we have a lot of Latin here. Stare decisis, certiorari, right? This idea of precedence and rule of 4. This is our important legalese that we have to learn. Okay, so what happens then? After the court grants the writ of certiorari, the justices do a ton of research on the facts involved in the case, right? Actually, most of the time their law clerks are doing a lot of the work and preliminary drafting. And like other appeals courts, like I mentioned, the Supreme Court doesn't hear any new evidence. Their considerations are based on the abstracts, the records, and the briefs of the case. The attorneys can present oral arguments, and justices can interject with questions or statements, and these are recorded by the court. And then the judges conference and they decide on a position. And when they reach their decision, it's opinion, or the opinion is written. And this is the statement by a judge or a court of the decisions reached in the case, how they ruled, and it also generally includes the reasons of its decisions and the rules of law that apply. A lot of times it affirms or reverses the lower court's rulings. It either agrees or disagrees with how that original case went down, right? Sometimes the case can also be remanded, and this means it's sent back down to the court that originally heard the case for a new trial. Like, for instance, if the lower court ruled that the person didn't have a case and couldn't even go to a trial, they said, this is not, this is not actually a real court case, we can't rule on this. And it goes up to the Supreme Court, and the Supreme Court says, actually, this is a case, and I want you guys to go ahead and, do an actual trial. Then they actually have to go back to trial. So typically the court's opinion is signed by every judge who agrees with it. If the Chief Justice, the head there, is in the majority, he or she writes it. If the Chief Justice is in the minority, the senior judge on the majority side assigns the opinion, right? So different judges can write the opinion. It doesn't have to be signed or actually claimed by any particular person. And this is called, when this happens, the opinion is per curiam, by the court. So you have different things that are happening, right? The opinion usually includes the reasoning of the decision. It either usually affirms or reverses the lower court's ruling, right? It either says yes or no. It can remand the case, sending it back down, and it could be written by one particular judge, nobody, signed by everyone who supports it, or just the Chief Justice, or literally everybody. You have a couple different types of opinions. You have a unanimous opinion. This is obvious, right? When all judges unanimously agree on a decision. When there isn't a unanimous decision, you have a majority opinion written, right? The one written by the people, or the one person that has the views of the majority, right? The people who ruled in the favor. And if it's not unanimous, right? Obviously you have a majority opinion, you might also have a dissenting opinion, right? So if there's a judge that disagreed with how the court ruled, he or she can write a dissenting opinion. Now there's also something called a concurring opinion. When there's a justice who feels really strongly about something or wants to emphasize a point, they write this concurring opinion, right? They concur with the majority view, but they also want to clarify a point or voice some kind of disapproval of how the decision was made, etc., right? It's kind of, that's dependent, right? You can see those depending on the case itself. So if you ever go to Wikipedia and you Google, a certain case, you can actually read or see the who was in the majority opinion, who wrote a concurring, if there was a dissenting or not. So it's kind of interesting, at least to me. Okay, so this is important. All federal judges are appointed, right? As we know, we learned this in the presidential chapter. The Constitution states that the president is to appoint justices of the Supreme Court, right? With the advice and the consent of the Senate. So the president provides the candidate, the Senate votes yes or no, right? Here we have a little bit of the nomination process, right? So the president nominates someone, they submit the name to the Senate Judiciary Committee invites the testimony, which is written and oral, to various hearings, and then they vote, right? They either reject or confirm the nomination. And once someone is appointed to a federal judgeship, this person holds the job for life. Until they resign, they can retire or literally die in office. How are judges chosen? Well, of course, competency is looked at, right? You have to be, a good jurist, but also political standpoint, whether you are conservative or liberal. And this plays a huge role in the Senate's decision to approve or reject the nomination. And because judges are appointed for life, have immense influence. The confirmations are understandably a big deal, and they sometimes can be pretty contentious. Here you have a list of the votes for different appointments by the president for the Supreme Court justices. Especially of late, there's been incredible battles over the confirmation of Supreme Court justices. For a long time, confirmations were not super controversial. You have Antonin Scalia, the late Antonin Scalia, and Kennedy's confirmation, right? The Senate voted literally 97-0. Of course, there were a couple of abstentions, it seems, but a pretty unanimous decision, right? But then I don't know if you can see this. So we have pretty much no conflict here, right? Everyone's like, yes, let's vote in Kennedy and Scalia. Now with Bork, there's some changes, right? Look at this. It becomes very contentious. What happened with Bork? Well, Reagan, as we can see here, nominated Bork, and he was qualified but was super conservative. And he would be replacing a judge who was a moderate, who was called a swing vote, someone that would vote sometimes conservative, sometimes liberal, depending on the situation. So liberal senators opposed the nomination. And this was actually the first time that the organized opposition was not based on qualifications, but the judge's judicial political philosophy. And after 12 days, the Senate defeated the nomination 58-42. So conservatives coined a new word to describe this phenomenon, this focus on political leaning, and they called it borking. Kind of an interesting word there. But it swings both ways, right? The judicial appointment faces consistent partisan nomination fights, intense media coverage, public opinion polls, packed hearing, and pro and con demonstrations. So the level of opposition usually reflects the hole that's being filled. So if an outgoing judge was liberal and there is a liberal nominee, or vice versa, if an outgoing judge was conservative and there is a conservative nominee, there isn't much opposition. Because the issue is over the split. Before Justice Scalia died, which was pretty recent, just a couple weeks ago, it was a 5-4 conservative split on the Supreme Court, right? There's 9 people, 5 of them were generally conservative, 4 were liberal. So changing the split, right, this balance here is what gets people up in arms, especially as President Obama is likely going to appoint someone liberal or sort of middle of the road. This is going to very likely change the split to a 5-4 liberal majority on the court. Remember, Justice Scalia is outgoing. He was very conservative. So changing the balance is making people very upset. People are definitely up in arms. The current Senate Majority Leader Mitch McConnell says he is not even going to hold a hearing for any judge that President Obama appoints or even meet with them. As we know, we just learned a couple slides ago, and also from the presidential chapter, right? It's the power of the president to appoint Supreme Court justices. Last time I checked, President Obama is still president and has this power as the president of the United States to appoint a new Supreme Court judge. The Republicans are very much against this. They are trying to say, or they are saying, that the appointment should go to the next president. Now, I'm not a constitutional law scholar, but I can read the Constitution, and so can you, and it's pretty clear on this situation. The president appoints judges of the Supreme Court, and the Senate advises and consents upon it. The Senate has a responsibility to fill vacancies. So this is becoming very contentious, and we'll see how it resolves itself, but there really isn't a reason to block this, at least in my opinion. So I also just wanted to highlight some checks on judicial power. If you ever think about the judiciary being extremely powerful, let's consider some of the checks that we have in place by the Constitution and other issues or other venues that check judicial power. So the judicial branch is one of the most independent, but it's not absolute. Like I said, there are political checks that limit the extent to which there's an exercise of judicial review, right? And the first is via executive checks. The only real check this branch has is via the appointment of judges. Rarely do you see the president not enforcing a ruling of the Supreme Court, but of course it's a lifelong appointment, right? So you are very careful, the president is very careful about who they choose, and that does sort of limit who is chosen to be a Supreme Court justice, right? So that's the executive check, right? The appointment by the president. Then we have legislative checks, right? And this can be firstly via the appropriation of funds. As we know, Congress is the one that controls the federal budget, right? Courts make rulings, but a lot of the times the legislature at the local, state, and federal levels have to appropriate the money to carry them out. If there's no money, the ruling doesn't really have a lot of teeth, right? Constitutional amendments that are passed via Congress can actually overturn court rulings. Your book mentions how the Supreme Court ruled that income tax was unconstitutional, right? At one point, income tax was not a thing. It was considered unconstitutional by the Supreme Court. But there was an amendment passed, the 16th Amendment, ratified in 1913 by Congress, right, that overturned that. And of course, we do have income tax in most states. And it doesn't stop at constitutional amendments. Congress can also rewrite old laws or enact new ones to affect a court's rulings. So when Congress passed the Lilly-Ledbetter Fair Pay Act, this was an awesome ruling a little while ago, it actually reset the statute of limitations for filing an equal pay lawsuit. It used to be that, so statute of limitations means that you only have a certain window of time in order to sue somebody or try to address any grievances, right? And before Lilly-Ledbetter, I think it was like a certain amount of time that you had to realize that you were getting paid unfairly. And after that window of time passed, you no longer could seek to redress that, right? So this thing actually reset that. Every time an employer issues a discriminatory paycheck, it sort of resets the statute of limitations. There, in effect, isn't any statute of limitations anymore. If you were getting paid unfairly based on your race or gender, you can pursue that in the courts and try to win redress for that. So those are some of the legislative checks, right? We have actual amendments, appropriations of funds, or changing of the laws themselves. Public opinion plays a role too. Unless someone complains and initiates a lawsuit, the courts have a hard time to enforce their decisions. So, for example, school prayer was outlawed in 1962, and people still did it for a long time. No one really complained. Until someone did recently, I think it was in the 90s, right? Unless you actually file a lawsuit, the Supreme Court doesn't get involved. They don't go searching for lawsuits. They are brought to them, right? So the people actually have to initiate a lawsuit. And there's also a sense that the judges are influenced by the attitudes and beliefs of the population. And in step with that, laws are influenced, right? Courts don't usually make decisions that are literally opposite to most of the public. But this is sort of natural, right? No one's an island. Everyone lives in the context of American society. Everyone's affected by the flow of ideas and change. So public opinion does sort of direct sometimes, at least influence rulings, right? Okay, so we have executive checks, legislative, public opinion. Now, we actually there's some checks on judicial power within judicial traditions and doctrines themselves. They're sort of built in. Supreme Court justices tend not to make broad, sweeping decisions on issues, but they focus on one issue or one small aspect of a case. And the doctrine of stare decisis helps here, since in following this doctrine, the courts are obligated to follow established precedents, right? And courts rarely overrule a precedent, so they have to be very calculated and judicious when it comes to rulings, since they last, right? Sometimes you see the Supreme Court exercising restraints and actually refusing to rule on a matter, passing it off to the executive branch or legislative branch or both. And this is generally if the problem or the issue is a political issue rather than a judicial question. So those are some of the checks. Just to finish up here, you are doing a response paper on the question of elections versus appointments for judges. So maybe even more relevant now since the issue of the Supreme Court nomination is currently going on. Should there be a change to the way that judges are chosen? Should there be elections instead of appointments, basically? As we know, we have learned, federal judgeships are appointed, right? There's no election process, but in 39 states, some or all of the state judges are chosen through competitive elections, right? People vote for state judges in many states. And so I kind of wanted to talk about this. Is this a good thing? Thinking about this, some ideas. Competitive elections are the most democratic way to choose judges. Is that a better idea? Elections can keep judges accountable to the public, right? They're not insulated from politics because they have to be reelected. Thinking about maybe the House of Representatives, right? They're considered the most democratic, right? Because they're constantly being elected. There was a UC School of Law study that found that elected judges write more opinions than appointed judges. Maybe that means they're more active. I don't know. This is sort of the pro side. Yes, we should elect judges, state judges. Now, then there's also the other side, right? That is against the election of state judges. Thinking about some of these issues. You are not going to get a fair and impartial judge through elections. Competitive elections rely on special interest money. Thinking about what we learned from the elections chapter, right? A lot of money goes into elections. Does that mean you're going to buy judges? Can someone be fair and impartial and maybe make a ruling that's sort of unfavorable or unpopular, but it's good, right? Thinking about like desegregation, right? That actually wasn't a super popular ruling. But the Supreme Court justices said, this is important. This is the right thing to do, even though some people don't agree with it. And you could see that, of course, at the state level as well, right? Thinking again about campaign contributions, they shouldn't decide judicial races. You can't end up with, or you might end up with business-friendly judges, right? The businesses that put them in position. So let's say that business is getting sued. Would that affect how the judge would rule? Potentially, right? And then also considering the fact that attorneys as a group give the most money to judicial campaigns. So again, sort of affecting the impartiality of state judges. So I don't know, I can see both sides here. So I want to know what you guys think. Let's let's write a really good response paper and then talk about this in discussion posts. Of course, as always, as you already know, I'm sure, any questions, please let me know. I just wanted to mention too, it's been a great semester. I feel really grateful to have you all in my class. I think we had a really good session, and I really wish you the best of luck in your continuing studies. And of course, I'm always here for you. Any questions or comments or anything, you know where I am. Thanks.